KPLAN and Legal Solution LLP. Excellence, experience, integrity.
Imagine a situation. One fine morning, out of the blues, a police constable or a bailiff from the court knocks your door and says, "Here is the summons from the court, and you have to appear before the court on the date mentioned in the summons." I trust it would be a nightmare for an average man. So he'll rush to a lawyer or a legal consultant and ask him, "Hey, what is this? Why am I been served with a summons?" Now, in this situation, I'm pretty much sure that any normal person rather, would get nervous about the situation that a criminal complaint is filed against him without hearing him or without his knowledge. Now, in this situation, the only remedy for him is to approach the court, find out what are the allegations that has been leveled against him. But friends, these were the days erstwhile before 1st July 2023, before the Bharatiya Nagarik Suraksha Sanhita 2023 came into force. In the old law, that is Criminal Procedure Code, there were no such provisions where the accused need to be heard before. In fact, it was a settled law of Supreme Court that accused has no locus standi to appear before the court and plead his case before the court takes cognizance of it. But after the enactment of the new code, that is BNSS, it has been shortly said, there is a provision under section 223 subclause 1 which says that before the court takes cognizance of a complaint which comes before the magistrate, in that circumstances, the court has to, the wording used is shall. The court shall issue a summons to the accused who has been designed to be made accused in a complaint. After hearing the accused, the court, if finds substance, then will issue a summons. So, in short and simple, now the settled position of law is that before the court take cognizance of any criminal charges levied against the accused needs to be heard in this case. Though the BNSS was enforced in 2023, till May 2026, there was a lot of debate about the scope and the applicability of Section 223 of BNSS. The issue in this case was, what about the matter which was filed prior to the advent of this act? Or what about the matters which are of a serious nature, like Prevention of Money Laundering Act, or the matters which are filed by the Enforcement Directorate, which has a financial implication? Some of the courts in the country had taken a view that the cases which were filed prior to the enforcement of this act will be governed by Code of Criminal Procedure, that is the old act. There was a lot of debate about the scope and applicability of this act. Now, in one of the matter in Uttarakhand, where the district court had taken a cognizance of a criminal matter before they could hear the accused. Now, the facts of that case were that the matter was filed much before the enforcement of the BNSS Act. And the court held in that case that the cognizance was taken on the second day of the enforcement of the Act. Now, in this matter, the court held that the since the matter was filed prior to the enforcement of the act and the cognizance was taken second day of the enforcement of the act, that is on the 2nd July, and so the process was issued against the accused without hearing. The accused in that case approached the court and filed an application to recall the issuance of process, which was rejected. The matter was heard before Uttarakhand High Court, and the court in that case held the judgment given by the trial court to be right. In a landmark judgment in Parvinder Singh versus Director of Enforcement, it was held that even if the matter is filed prior to the advent of the act, in that case, and if the cognizance of the matter is been taken subsequently, the court held that no, the BNS Act would be applicable, and the debate going on was settled by the Supreme Court in this case, stating that it is a mandatory provision given by the statute and the accused need to be heard before the cognizance has been taken. There was a debate that whether the serious offences like enforcement directorate, the cases filed by the enforcement directorate or regarding the PMLY cases. In this case, court says even if the allegations are serious, but accused is being given a fundamental right to be heard. And this is, for the first time, the Supreme Court held that it rather anchored the Article 21 of right to life and liberty. And in this case, court held that yes, the accused has to be heard first, and if the court finds substance in the complaint, then the issuance of process needs to be proceeded against the accused. Because of this enactment, there are a lot of unscrupulous complaints which was filed or which used to be filed against an innocent persons. But there is a big paradigm shift after this new act, and more particularly the confusion which was there in the legal fraternity about the applicability, the scope of this section. But in Parvinder Singh versus Director of Enforcement, this law is now settled, and it is crystal clear that it is mandatory for all the courts in this country to hear the accused first and then to proceed against the accused. Sum and substance, it is any order or the issuance of summons or issuance of process against the accused without hearing the accused or giving an opportunity to plead his matter or plead his defense, the order would be void ab initio, that is invalid order. It had become a trend in this country that to score an edge over the civil litigation, it was an offshoot to file a criminal complaint in the court. And the accused had no other option than to wait for the summons, and after the issuance of process, the accused had only option to appear before the court, furnish his bail, and thereafter, if he finds that there was no substance in the allegation which was been made or the sections are wrongly applied, then the only remedy available to him under the earlier law was to approach the higher court and file the revision. Now those days are gone. Those days are gone. You can make out your case much prior to taking the cognizance and see to it that, or plead to the court that this is a false allegation, and you can bring out your defense at a very threshold of the matter and see that the complaint gets dismissed.
KPLAN and Legal Solution LLP. Excellence, experience, integrity.